Welcome back. It's no secret that the structured settlement industry has been critical of the secondary market from the beginning. Factoring companies have sometimes been called unscrupulous and predatory. The biggest complaints of late have been related to its cash now advertising. The factoring community says advertising helps companies survive in a very competitive marketplace and that they provide a very critical service to injury victims who need to pay for things such as unforeseen medical expenses. They also argue since factoring transactions need court approval, there are sufficient safety precautions in place to protect the injury victim. My guests are John Derer from 4structures.com in Stamford, Connecticut. He is considered a structured settlement watchdog. Welcome back, John.
Thank you, Scott. Good afternoon.
And Matt Bracy, General Counsel for Settlement Capital Corporation in Dallas, Texas. Welcome back, Matt.
Hi, Scott.
Let's start with factoring company advertising and how it relates to business practice. John?
Well, nothing has created more consternation among people in the primary structured settlement market, which I defined as people who are creating brand new structured settlements. It's also created consternation among judges and attorneys whose clients are getting into structured settlements than the factoring industry. When I talk about factoring, I'm not talking about everybody in the factoring industry. I'm primarily talking about certain advertising practices by certain members of the factoring industry.
Matt, some of John's biggest complaints come from the cash now advertising. Can you discuss that?
Well, I think that's part of what John's probably talking about. I think there are some factoring advertising practices that have traditionally irritated the primary market. And let me just say as an initial point that, and I've said this before, but nothing that the factoring market says or does should ever imply that we don't think structured settlements are great for most people, really do what they're intended to do for most people, and so forth. I mean, it would be absolutely idiotic, frankly, for us to say or do anything to harm the primary structured settlement market. Simply not true. Structured settlements are a very good thing most of the time. Our only point, and it's almost a footnote in a sense, since only about 7% or so of people we think who ever have a structured settlement have a need to factor. But we think that the footnote should be, if you will, that if you do have a need or something changes in your life, that there is an option to sell some or all of your payments.
The point of today's piece is really to try to come up with some type of solution. I think I'd like to start by identifying or basically stating that there needs to be a clear path for consumers to find structured settlement information. And I think over the years the lines have been blurred between what is known as the primary market and the secondary market. What I mean by the primary market is the people that are helping people get into structured settlements, and the secondary market is people who provide liquidity for people whose needs may change over the course of due to the passage of time, and they need liquidity, and there's a well-established process that requires court approval for someone to obtain liquidity. The area that I and many other people in the primary market have a problem with is the manner in which some factoring companies advertise. I'm going to enumerate some of them, and then later on we'll discuss some potential solutions. Scott, you mentioned the cash now situation that's been going on for 3 or 4 years. I've highlighted that consistently on my blog and in previous video podcasts. I think that has largely dissipated, or it's not as much as it was in the last couple of years. The one thing, or several things that are persistent that I find to be rather offensive, and I don't think it's productive for either the primary or secondary market, is the advertising. We have a number of factoring companies who are advertising that they give annuity quotes. Now, if one understands what a structured settlement factoring transaction is, there is no annuity quote. What a factoring company does is provide liquidity. What happens in a structured settlement factoring transaction is there is a transfer of structured settlement payment rights. Now, the actual annuity that is paying out structured settlement payments, there is absolutely no change whatsoever in the ownership of that annuity. Most structured settlement annuities are owned by assignment companies. As a result of the structured factoring transaction, the ownership still rests with the assignment company. The only difference is that the payment rights may be payable to a different party as a result of the transfer. So you have a number of companies that are advertising that they give annuity quotes. Annuity quote, people that actually give annuity quotes need to have insurance licenses because annuities are manufactured primarily by insurance companies. So that is one particular problem. There's also another problem in that we have companies that are offering certain types of incentives for people to sell their structured settlement payments. In essence, they're providing inducements. Some of those inducements are a little bit excessive in my opinion. It could be financial consideration. There was one company that was offering tiered prizes. In other words, the more that you factor, the more that you sell of your long-term financial security, the bigger the prizes are. One company was giving away a Mercedes-Benz back in 2007. If you go back to our blog, you can actually see a copy of that. If anybody needs a copy of that, I can supply it. But surely something like this is not something that should be considered the right way of doing business. But nevertheless, it goes on. And I think that there are some solutions, and we'll discuss that. But those are two examples of what I feel are egregious behaviors that need to be corrected.
Yeah. Let me address the first one first. The issue of calling it, let's say, an annuity quote, or let's say even if someone were to say sell your structured settlement, which is not really what happens either. You know, John and I can agree on the nuances and the technically correct way to characterize what happens in a structured settlement factoring transaction. But ask yourself this: who is really being harmed by that? If someone is searching for a means to sell some of their future payments, they may not even be able to articulate it in those precise terms, but they know what they want. They get, $500 or $1,000 a month in structured settlement payments, and they have a need to sell a part or all of those for an articulated reason. They know what they want to do. Now, they may not have the precise legal definition down exactly of how factoring works, but when they search for something, if there's a search term that says, I want to sell my annuity, regardless of whether or not they can do that or not, and they cannot, it doesn't really matter much. They're still looking for the same thing. Someone who instead really wants to, let's say, buy an annuity, I think that's a different person probably, and if they come to our company or any other factoring company, they're going to find out that they can't buy an annuity that way, or they can't do something else that may be more towards the primary market. For instance, if there's an advertising confusion between structured settlement consulting, or let's say there's a structured settlement expert, and that's really a factoring company, but this is a plaintiff who's in a personal injury case who for some reason on their own wants to find out more about how I can maybe get into a structured settlement, they're going to find out pretty quickly that they've called the wrong place. I think it's a distinction in some ways without a difference, because, or at least without a significant difference to the consumer, because the consumer is not the same person. It'd be like me putting in, Pillsbury in a search box, and what I really want is a recipe for pie, but what I get is a law firm named Pillsbury. I know that I'm not going to get a recipe for pie by calling the Pillsbury law firm. And so I think in a certain way, I think that distinction doesn't really matter to the consumer. Now, it may matter to other people, and we can talk about that also, but I don't think it matters to the consumer that much. I think they know what they want. The issue of, you raised the issue, John, of the incentive programs too, that, some of the advertising issues, I think, you or I or anyone else may find objectionable and bad taste and so forth, but, whether or not they really create harm is another thing entirely. I think it may be a bad idea, me personally, I may think something may be a bad idea, but ultimately if you have every transaction being scrutinized by a court to determine whether or not that specific transaction, selling a certain defined number of payments to a factoring company for a defined amount of money, is in the person's best interest. I think that's the court's charge, and that's what they do. And I think that, if you happen to throw in a toaster, every bank in the world at one point or another has thrown in, toasters and other things like that to encourage people to use them over someone else. The transactions are still being scrutinized by the court in this case. And I don't see that as being something that should be, regulated out of possibility, simply because I don't think the consumers are being harmed by that.
Well, Matt, I have to say that I disagree with you on this particular point. Let's take a parallel. We've got life settlements, which many companies in your industry participate in, and those particular companies have agreed to be licensed for life settlements. So I say, why not license structured settlements, or why not license factoring companies for structured settlements? The issue is the advertising and the solicitation practices. We know that almost every insurance department is requiring additional training for annuity agents to sell annuities to seniors. Okay, seniors are, the reason why they do this, they perceive seniors as a vulnerable sector of our society who need to have clearly defined advertising directed towards them. They can only be contacted a certain way. And again, the state regulators and the people who enact those laws, the legislators, they recognize that this is a vulnerable sector of society. Now, I am not saying that everybody who is coming to a company like Matt's or another company that is a member of the National Association of Settlement Purchasers doesn't know what they're doing. But there are a good number, I would imagine, people who elect to transfer their payments who have got themselves into trouble. They may not be sophisticated. They may have other management issues, money management issues, and they need to be solicited in a way that is truthful. They should be solicited in a way that is not encouraging people to destroy long-term financial security for reasons that are not sound reasons. Now, I understand that it has to still get by the court, but we would tie up a lot of less time in the court system if we had, and I'd imagine cases that don't go through would go through a lot faster if we had clearly defined goals in getting these things through and clearly defined solicitation practices. I really, truly believe that why are we regulating insurance agents? We've got an overregulation of insurance agents and securities solicitors, and the only regulation with respect to the factoring industry is a judge, one individual judge who makes a decision about whether the transaction can go through. At that point, the person who is selling their payment has already been solicited. They might be all ready to get their prize, which, by the way, I don't mind if someone's getting a $10 toaster. As an insurance agent, we're usually limited to like $25 or some nominal gift to Road Atlas in the old days. But we're talking about one particular company was offering bicycles, Bang & Olufsen stereos. Some are offering actually giving people cash. This would not be legal if the person was licensed. Now, I'm not saying it's illegal because there is no regulation, but I believe that we need to have a clearly defined path for consumers of whatever type. Whether there are consumers who are looking to get into structured settlements or looking to get out of structured settlements, there should be a clearly defined path for them to go through. They shouldn't have to, by mistake, go to a factoring company, or because there's 8 out of the 10 listings on the first page of Google are factoring companies because they've labeled something a certain way. I don't think that's fair to consumers. I'm not like jealous because somebody has got a better page ranking than me, or nor should anybody else be. They've all credit to their advertising agencies. But I do think, and I find it objectionable, and I do believe there's other people who find it objectionable when terms are being misused. I do think that we have a common goal, Matt, in that if people are, your industry cannot benefit in the long run if judges, if plaintiff attorneys, and others do not want to put people into structured settlements because they perceive a certain level of ethics or a certain level of professionalism. I believe that if we can establish a truthful and clear path for consumers of whatever type to get to the information they seek, maybe through some industry discussions, or perhaps through licensing, in a more extreme measure, but we need to establish that clear path, in my opinion.
Well, let me talk about licensing for a minute. our regulatory scheme, if you will, or process for structured settlement factoring is individual case-by-case scrutiny by a judge. And that's in addition to required disclosures that must be made. It's in addition to, in some states, requiring they receive independent professional advice, and in some states, requiring that we advise them to seek it and they can waive it or actually obtain it. That is the regulatory process that we have that regulates our industry. Now, some would say that that's actually more scrutiny than a licensing plan. For instance, let's remember that the primary structured settlement market, structured settlements when they're established for someone, unless it's a minor, are typically not court approved. And so there is no court in that case who looks at the individual transaction and decides if it's a good idea or not a good idea. It's simply an agreement made to settle the case in that way. And that's an agreement between the parties ultimately and the insurance companies that are involved.
May I just interrupt you for just a second? Because actually that's not entirely correct. If you have cases involving minors, those always require court approval. If it's a case involving incompetent, always requires court approval. If it's a workers' compensation case, it requires workers' comp board approval. And if it's a death case, usually there's a probate court involved. There might be a guardian ad litem involved, and there is a regulatory process there is a judicial process to establish the structured settlement in those instances.
Okay, but it's true that not every structured settlement is approved by a court. Is that not right?
That's correct.
Okay. So there is no scrutiny on an individual case-by-case basis in that case. Every single factoring transaction must be approved by a court, period. There is no exception. There is no way around that. Okay? So the level of dissecting the transaction, whether or not someone is receiving a good deal, whether or not it's in their best interest, is up to the individual judge, usually in the county where the person lives, who can be sensitive to the issues that are prevailing in that area, more sensitive to what's happening in that particular geographic spot at that moment in time, economically, for instance. Maybe sometimes we'll even know the person who's selling the payments. That happens with some frequency. So that is the plan that we have. Now that I think washes out a lot of the problems that may come up with, well, were you enticed to come and try to sell your payments by this flashy advertising or that? Ultimately, it doesn't matter, I don't think, as long as the transaction on its terms is in the best interest of the person selling. And that's exactly what the judge is charged with finding. So now the licensing issues are, you'd have to have a regulatory scheme there for licensing that would establish all kinds of rules and regulations on exactly what could and could not be said. Now this is not an insurance product. We are not in the business in factoring of dealing in any kind of insurance product. That's a different thing. What we do is we buy structured settlement payment rights. They happen to come from an annuity, but that does not make our business the business of insurance in any way.